Testing.
That's this meeting to order. And,
Mr. Chairman,
yes, sir.
Jason Robbins moved to recess the February 2026 Board of Adjustment regular meeting to reconvene at the Southport Fire Department Emergency Operations Center located on 1011 North House Street, second floor of the fire station.
Have a second?
Second.
All in favor, signify by saying aye.
Aye.
Opposed, same sign. We are now moving to
Fire station.
Folks,
Mr. Chairman. Jason Robbins, move to reconvene the February 24th, 2026 Board of Adjustment regular meeting at the South Florida Fire Department Emergency Operations Center located on 1011 North Howe Street, second floor of the fire station.
got a second?
Second.
All in favor, signify by saying aye.
Aye.
All opposed, same sign. Okay, motion carries. We'll call the meeting to order here in our fire department. We will stand for the pledge of allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. I've been informed, that this room is mic'd entirely, and so if you're whispering to each other, and if you're in the audience and you're whispering, it's gonna be picked up, so we ask you to please try to refrain from, you know. I gotta talk to you. I gotta worry about me more than anything. But, yeah, so, another thing too, we had a fairly, complex meeting last month. A lot of legal stuff going on, so we, Jason and I did meet with our attorney and discuss some things, and one of the things that came out of that that I just want to throw out here to you all is, that based on that, the late filing that we had at the last meeting, I want to inform everybody that in the future, late filings may result in a continuation of the issue to a following meeting, and it will be based on the complexity of that issue. So we will have that right, and we'll exercise that right if needed. So, is there anything you want to add to that, Rick? I know we have people here signed up to speak. I've got a list here. You'll get your opportunity. And so, at the appropriate time. Okay, folks, got a motion to approve the agenda? Okay. All in favor, signify by saying aye. Aye. Opposed, same time. Thank you. The hearings today, we have two or three, excuse me. We have an appeal of an administrative decision and two special use permit requests. So the hearing tonight, the hearing is going to be a quasi judicial evidentiary hearing. That means that it is similar to a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of administrative and legislative land use decisions. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. It is a decision constrained by the standards in the ordinance and based on the facts presented. You will be speaking as a witness. Please focus on the facts and standards, not personal preference or opinion. The meeting is open to a public. Parties withstanding have rights to participate fully. Parties are limited to the applicant, the local government, and individuals who can show they have standing and will suffer special damages. Special damages may include parking, stormwater runoff, crime problems, or property value impacts. Proximity alone is not enough to prove such. Other individuals may serve as witnesses when called upon by the board. General witness testimony is limited to the facts, not opinions. Individuals who are providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. And I will stop right here. This issue of who has standing to speak at the meeting is one that always comes up. If you're going to be coming up here to speak, it's not about personal opinions. It's not about, whether you like something or like something. It has to be based in fact. If you're going to make claims about it'll reduce my property values, then you need to have an appraiser official. You can't just state that that's going to happen. It needs to be proof from an expert. So just want to make sure that everybody understands that that's kind of how we work with standing. In this hearing, we will hear from the town staff, then from the applicant and its witnesses, and then from opponents to the request. The applicant may choose to reserve time at the end for rebuttal. Parties may cross-examine a witness after the witness testifies when questions are called for. If you want the board to see written evidence such as reports, maps, or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. And I think, right now, if anybody on the board have any conflict of interest or any ex parte communication?
Mr. Chairman, I will need to be recused from hearing 26 during the reading.
Okay. Okay. And he's going to recuse himself and I guess stay in the room.
No, I'll leave.
Okay.
It's okay. To stay.
Okay. All right, anybody else? And again, anybody need to sign up on the sign up sheet? We got 4 names on here. Okay, thank you. Okay, our first order of business,
Mr. Chairman, I think we need to approve minutes.
we did,
We approved the agenda.
oh, the agenda, okay, yeah.
We did not
All right,
approve.
thank you for that reminder. Do I have a motion?
I move to approve the minutes from the January 27th, 2026 meeting of the Board of Adjustment. There is one slight thing I'll point out. On the very last page, it says motions and seconds were made by Mr. and Mr. So I guess we need a person in there sometime. That really matters.
Okay, any other? Oh, get to the first. Okay. Oh, that's,
Didn't get a second.
I'll second it.
Rodney seconds.
all in favor, signify by saying aye.
Aye.
Opposed, same sign.
Mr. Chairman.
Yes.
Abstention.
Okay. Yeah. Got one extension, so good to go. This is our first one. Our first case will be the accessory dwelling at 306 West Moore Street. And who is representing? Staff, please come up. Whoever's representing. And you are?
Wendell,
Okay.
staff,
Okay.
sorry,
You swear to tell the truth, the whole truth, and nothing but the truth, so you have.
I do.
Thank you, sir.
Yes, thank you, Chair and members of the board. Sorry. Different venue. All right, so tonight we're here for special use permit SUP 26-01. Is a request submitted by the property owners of 316 West Moore Street, Mr. Scott Fitzgerald, not to be confused with Mr. Bill Fitzgerald of 2 months prior. It's a totally different Fitzgerald in a different residence. So I just want to make sure that we're all on the same page there. 316 West Moore Street, they're seeking to convert an accessory structure into an accessory dwelling units. This slide shows both the aerial image of the lot as well as the zoning designation of it and the surrounding lots. For the record, the lot is approximately 82 square feet. It is zoned R10, and mostly bordered by R10 single-family residences, except for a BD parcel across from West Moore Street. We have another view of the lot taken from West Moore Street. This image depicts the single-family residence and an accessory structure in the foreground. It should be noted that the existing accessory structure is to be demolished and rebuilt to meet contemporary floodplain, building code, and zoning standards, as it currently does not meet those standards, specifically the zoning setback. depicts the the slide depicts the site plan of the existing SF single family residence and accessory structure. As it currently sits, the structure does not meet the minimum 5-foot side setbacks. Though the structure is legal non-conforming, general statutes and our UDO prohibit the increase of any non-conformity, which precludes turning this into an ADU. The applicant is set to demolish the existing structure and rebuild further into the lot so that the new accessory structure will meet contemporary floodplain standards, building codes, and the minimum 5-foot side setback, all of which is by right land use for the homeowner. So essentially, regardless of this vote tonight, they can still very well demo and then move their structure of desires over to the right, meet our setbacks and rebuild, and just not have an ADU. So I make sure it's very clear that we're here not for the determination of the structure, but for the determination of an accessory dwelling unit within the structure. The applicant, excuse me, what is being requested of this board, however, is, I already explained that. Here's a rendering of the proposed structure's front and rear elevation. Structure is to have a max height of 27 feet measured from grade. And this is what the sides of the structure will look like. As evident by table 3.1 of the UDO, the proposed accessory use requires a special use permit review and is to meet the specific use standards established in section 3.6 of the UDO. Said standards are here. I'll read them out to you. There's a total of 8 of them. Number 1, an accessory dwelling unit may be within, attached, or separate from the principal residential structure. In this case, the proposed dwelling will be detached from the principal residential structure. Number 2, the principal use of the lot shall be a detached single-family dwelling units, dwelling built to North Carolina State Building Code standards. That will still be the same. Number 3, no more than one ADU will be permitted on a single deeded lot in conjunction with the principal residential structure. There are no other ADUs on the property.
Wendell?
Yes, sir.
Momentum going, I don't mean to derail you. Number 2. Stuart?
Yeah, so on the it's on Westmore Street. It's like the only problem.
Yes.
Yep, sorry. And you'll see that on SUP 26 Tech 03 as well. I messed up and kept the word Stewart Street. I apologize.
Just wanted to.
Yep.
Those 2 minutes.
But it's Westmore Street that we're talking about. So number 4, the ADU shall be owned by the same person as the principal residential structure, which in this case it will be. Number 5, the ADU shall not be served by a driveway separate from the serving the principal residential structure. Essentially, they're going to be keeping the same driveway. It's not going to be a problem. Number 6, there shall be a separate parking space for the ADU subject to the off-street parking requirements. Parking space will be available on the driveway. Number 7, the ADU shall not exceed 800 square feet. And here they are proposing 530 square feet. That way they can keep the minimum 5-foot side setback. And finally, number 8, detached garages with a second floor accessory residential dwelling may not exceed ground level building footprint area of 530 square feet. It shall be constructed behind the front building line. All that is to say that the ADU is detached in less than 530 square feet. So it meets those standards. So in summary, the applicant is requesting of the board to be granted an ADU for a proposed accessory structure that they are going to be demoing and rebuilding, essentially. Currently, the structure doesn't meet our setbacks, therefore they can't get the ADU, so they will be demoing it and then rebuilding to meet our setbacks. That concludes my presentation. I can answer any questions regarding it or the staff report.
Questions, Ben?
See, Wendell, you made a point, I just want to be sure I'm clear on. In order, because this existing structure does not meet the conforming standards, it can't get an ADU as is.
Yeah,
But they have the right to rebuild it if they move it if they tear it down and and move it within the setbacks and according to code, all that.
Correct, yes, sir.
And so it seemed like there was a hair split here on whether we're approving the proposal for the ADU or just proposal for using part of a by right structure as an ADU.
No, I apologize if that wasn't clear enough. So basically, you guys are just voting on allowing their proposed structure to be an ADU. That's it.
And it meets all of the standards.
Exactly. Now, I am not of the board. I'm not here to tell you conditions. I wanted to make a point so that if you chose to make a condition of approval, it would be based off of your conditionally approved pending building code. You meet all the new building standards, setbacks, floodplain, all that stuff. So that's why I painted that picture. It's just so that you guys could make that condition if they were your choice.
It's clear to me now. I appreciate that.
Any more questions, Lynn? Okay, thank you, Lynn. Do we have someone from the applicant to speak or have anything they need to say?
I don't have anything really to say.
Go for it.
Oh, sorry.
I didn't know you were the applicant. I would ask you to, so you can swear.
Okay,
Your name and address, and then I'll swear you in.
my name is Lindsay Ursa. And do you want my personal address?
Doesn't matter. Yeah,
Okay, 866 Pantego Boulevard, Bolivia, North Carolina.
raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth. That'll be done.
Mhm.
Thank you.
Basically this unit, the owner wants it just to be a really cool guest room. It's never gonna be considered as an Airbnb or anything of the sorts. He plans to build it just like the house. He wants to keep all the similar features, and stay in compliance with everything. The windows, the doors, everything will be the same. The only nuances were, in that square footage that we provided, the steps and landing were not included in that. That's all. Let's see if any questions.
Questions up front?
We're actually flipping the garage in. No, if I'm reading these drawings correctly, it looks like the garage is now 180 degrees opposite where it is today.
Thank you. Right.
Sorry. This one's okay. Let's take a look real quick. So that is, they are on the other side of what the road is. Well, what's that road back here? Is it Brunswick? Thank you. So it is essentially possible that they could access the garage from Brunswick. I didn't catch that was going to be part of the design. I apologize. Second.
Shows up in the south elevation.
So if well, this is the north elevation right here.
The south elevation will be where it should be.
No, but it shows the existing garage ghosted out. In other words, that's, you look at the proper south elevation.
Yeah, so to Mr. To Tuck's point, so this would be the Brunswick Street side. Is I only know that based off of where the ladder well is, the staircase is. So the staircase is going to be east of the structure. And here we have what appears to be a garage door. I don't know if that's decorative. It didn't come into part of the equation. And then here is what would be facing West Moore Street.
How does the garage question not come into the equation? Because if it's facing toward the north, toward Brunswick Street, and that would be establishing a separate driveway for an accessory dwelling unit.
Great question, sir. I would say it's one continuous driveway.
But if the Brunswick Street is at the left, runs it down the left-hand side of the screen there. And if the garage door is facing Brunswick Street, the driveway that you just pointed at comes off of West Moore Street.
Yes, so here's the stone driveway. Here's Brunswick Street.
Am I not seeing that correctly? that there's another the driveway for the main house comes off of Westmore Street.
That's something,
Is there a garage door on this side where, right where the proposed is? Is there a garage door right there where you're?
no,
There is,
sorry.
I'm not sure. Sorry.
If that's what you're asking, yeah. 'Cause they're
We've
coming in
got
from that side.
We've got the two driveway question.
Right.
Which we wrestled with quite
A
often.
couple meetings ago, yeah. Is there a garage door on that side?
So by design, it looks like this is the garage door. And then here's the ladder well.
And that faces.
So if the ladder well is right here, that would tell me the garage door is right here.
If that's a garage door, then it does face Brunswick Street.
It does.
Think to create another driveway down the road, or is that part of the?
I don't think it creates another driveway.
How does it not create another?
Particularly with garage doors.
That's paved.
Stone. It's stone.
Well, it's already a driveway.
Yes. So this is already a driveway right through here.
I mean, in the back.
Yeah, and back to Brunswick, they're showing.
There's already a driveway apron that exists there, right?
I would have to
Not
double
an
check that.
Accessory dwelling unit there. And the code is it pains to prohibit separate driveways for accessory dwelling. Unit.
So, yeah, we'll look into that real quick.
Well, that may impact our decision.
It begs the question of whether this is the appropriate format of a request that you should move forward with variance.
Man, I mean, is the intention to use from the backside as a driveway
So I was
into
told,
the building?
I was told that we were using the existing driveway. That no additional driveway will be added to it.
But is there an existing driveway that leads to that new building now?
I will have to, I'm sorry, drive now.
There's an existing drive now.
So how does that impact the request versus the UDO and?
So the request remains the same, asking for the ADU. I don't think that it changes. Let me go back to the numbers. Sorry.
Do you have that picture from the back? From Brunswick Street looking towards the existing?
No, I don't. So,
The aerial shows existing.
yeah, let me show you the aerial.
I'm reading it right.
So, yeah, here's Brunswick Street. And it does look like it paves out right here.
Yeah, there's existing. Grass.
There's also,
I guess,
an existing garage door on that end.
Even right now, under the existing accessory dwell.
It's not an existing.
It's not a joint accessory.
Well, it's an existing building.
It's,
Yeah.
yeah,
The existing structure, garage structure.
so it's always been.
Right.
It's a building.
So do you see that impacting the request based on no separate driveway for accessory dwelling?
Yeah, I just want to read it one more time. The ADU shall not be served by a driveway separate from that serving the principal residential structure.
That building creates a separate entrance.
It does.
There's absolutely no doubt, because the South Crofton elevation, whatever that refers, you see the outline of the existing building.
Yes, sir.
And it shows the garage now, shows a flip condition, so it really changes the dynamics. That's existing now.
It is existing now. However, number 5 still stands. The ADU shall not be served by a driveway separate from that serving the principal residential structure. The standard isn't that the garage shouldn't be served by a driveway. It says the ADU shouldn't be. So
Are you separating the living quarters upstairs from the garage?
yes, sir. The living quarters would be upstairs, separate from the garage.
The entrance to the living quarters is served by the first garage
The entrance to the living quarters will be served by that ladder well that is
on the
on the
front.
Existing driveway side.
Need to hear more about how this driveway that's approaching the garage underneath an accessory dwelling unit wouldn't serve that unit.
I don't think that's something I can argue.
Okay. So do we-
I keep reading number 5, and it sounds like we found an issue that I didn't catch earlier.
Would it be? Mr. Chairman, may I make a motion?
Sure.
I'd like to move that we table this matter and refer it back to staff for further review with the applicant.
Do I have a second? Second. All in favor signify by saying aye. Aye. Opposed, same sign. No. Let it know here. Right, motion carries.
Mr. Chairman, may I be excused for the next hearing? All is here.
I guess we, there was a motion carried to continue. Okay. Questions or comments about where we're at? Our next application is 2603 for another accessory dwelling unit and staff.
Okay, thank you again, Mr. Chair, members of the board. Special use permit 2603 is a request made by the property owners of 508 West Brunswick Street. The applicant, Mr. Bandera, is seeking to convert the upper level of an existing accessory structure into an accessory dwelling unit. So a couple of points of distinction about this property. One, the property was in fact awarded a special use permit several years ago for an ADU. However, the permit was not exercised within the time limit of 12 months as set by the UDO, and the SUP became null and void. So essentially because they didn't, the property owner didn't pursue the ADU within 12 months of being awarded the special use permits, it became a moot point. And number 2, though the property is zoned R10, the lot is approximately 8,400 square feet. And per the UDO section 39B1, the parcel is afforded setback exceptions. In this case, setbacks are going to be reduced by 15%. And I'll get more to that throughout my presentation. This slide shows both the aerial image of the lot as well as the zoning designation of it and the surrounding lots. For the record, the lot is 8,400 square feet, zoned R10, and is bordered by mostly R10 single-family residences. Here we have another view of the existing accessory structure. This image depicts the front entrance and staircase on the west side of the building. This slide depicts the site plan. And this slide depicts the site plan of the existing single-family residence and accessory structure. The proposed ADU is less in height. Yeah, it is less in height than single-family residence. The approximate height of the ADU would be 24 feet, 23 and some change. And the second floor will be about 789 square feet. Here's a rendering of the proposed structure's front and rear elevation. The structure is to have a max height of 24 feet measured from grade. And this is what the sides of the structure will look like. As evident by table 3.1 of the UDO, the proposed accessory use requires a special use permit review and is to meet the specific use standards established in section 3.6. And here are those standards. I'll read them off again. Number 1, an accessory dwelling unit may be within, attached, or separate from the principal residential structure. In that case, it's suited. Number 2, principal use of the lot shall be a detached, single-family dwelling built to the North Carolina building code standards. It is. Number 3, no more than one ADU shall be permitted. There are no other ADUs on the property. 4, the ADU shall be owned by the same person as the principal residential structure. That is the case here. 5, the ADU shall not be served by a driveway separate from that serving the principal residential structure. The structure will be served by the same driveway that serves the single-family residence here. Number 6, there shall be a separate parking space for the ADU subject to the off-street parking requirements of section 3.14. In this case, the parking space will be available on the driveway. Number 7, the ADU shall not exceed 800 square feet. Well, in this case, the proposed ADU is 789 square feet. And then finally, number 8, this blurb about detached garages with a second floor accessory residential dwelling may not exceed a ground level building footprint area of 530 square feet and shall be constructed behind the front building line. That's all to say that the accessory dwelling unit does meet the standard, seeing as it is not a detached garage. In conclusion, the special use permit seeks approval for an ADU that is 789 square feet and is on the upper level of the detached garage or structure, excuse me. Staff find that the application is complete and that the applicant's proposal meets all the residential accessory dwelling unit standards established in the UDO. I can answer any board questions regarding it or my presentation.
You done?
Yes, sir.
Any questions? Chris, would you like to come on? Representative Young? Yeah. Thank you, Wendy.
For the site plan.
For the record.
Rich Bender, 409 North Burlington, and representing Jennifer Steiner.
Swear to tell the truth, full truth, nothing but the truth.
I do.
Thank you, sir.
Thank you for letting me speak. We were, again, like Wendell mentioned, we had an approval on this. I was involved in the project back in February 2021, where we did receive an approval for the SUP where it expired because of projects that take place. The conditions of the approvals are no different really than what exists today, with the exception that the height of accessory dwellings have to be 30 feet rather than what was 40 feet, and this is 24 feet. As you know, we wouldn't be here unless we felt we met all the standards. Say the owner, Ms. Stenner, has done some improvements in 21 that addressed a structural report that was part of that application back then that included flood vents and other repairs to the deck, the stairway. And unfortunately, that permit expired, and we're here today for that. I think that that's really all I have to say. I'm just kind of reiterating what Wendy just said as far as be happy to answer any questions.
Questions of Mr. Bandera? Question? Okay. And, now we'll do our motions. Now we'll do discussion. Do I have a motion? Number 1, please.
Objection.
Pardon? Oh, that's right. Yeah, I'm sorry, I apologize. Do we have anybody who wants to speak on this? Okay, come forward.
Okay.
I apologize.
And she said right here, hang on just a second, the building is mine, I mean, this room is mine. Okay, thanks to,
Yes, where?
spinal surgery, last year. I can't stand for more than about 5 minutes. And,
And you are,
guys
for the
have to
record,
pick me
please?
up off the floor, so can I sit here?
Please.
All right. You can
For the
swear in.
record, who are you?
My name is Jane Lo Davis. I live at 504 West Brunswick Street, immediately adjacent to the Appleton property. I've lived there for 14 years.
Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you, man. Take a look at it.
My lovely assistant will hand out some a packet of information. I don't have slides. What I have is a packet of information. You have them all. Great. There you go. There we go.
If there's another.
Deputy City Clerk will also make. Yes. Did you have, do you have one? Did you get?
Yes,
Okay. Thank you. I hate to have people read to me what you have in front of you, but I'd appreciate it if I could go along that way because it will help me and I hope help you follow along the my objections. Please note for the record, my role as a sitting Southport Alderman for Ward 2 is not relevant or pertinent to this hearing. I am appearing here today solely as a private citizen and in my own personal interest as a neighboring property owner. Nothing I say today should be interpreted by this board, by the city staff, or by Southport residents to have any official bearing on the case at hand or on this board. And my statement should be treated as you would those from any other party withstanding on a matter before you. Regarding my standing to speak to you today, I can tell you that the accessory building at the back of 508 Brunswick directly impacts my property and property interests because it overlooks my home and the back half and west side of my lot at my house. It is dramatically visible from inside my house, my back deck and porch, and my west side yard. Any activity in or around that accessory building, and this is an existing building, around that building, people, vehicles, lights, equipment is visible and audible from my home. For example, vehicles pulling through the driveway to access this accessory building pass 7 feet from my bedrooms and bathroom windows. The site of this accessory building is in the AE flood zone. And water draining from that building and the fully paved apron surrounding it enters and flows through my yard. Any intended uses of the property could exacerbate any of those issues. The property already has an approved permit for a 225 square foot, 15 by 15 feet swimming pool, which is not shown on the site plan submitted to you. The pool introduces an element of unknown, an unaddressed, frankly, element of unknowns into the circumstances and consequences for me, my neighbors, and of any additional uses. Please see attachment A. That is the building permit for the pool. I wish I had a nice slide to show you, but I. So you have it this way. This permit was granted December the 4th, 2025. Having said all that, I respectfully request that you bear all of this in mind as you consider special use permit application SUP 26ZA3, and that in regard to your 4 motions, as you deliberate this application, that you probe several questions. May I stop here and ask if there are any concerns or questions regarding my standing?
So far, I mean, we're getting close. And, I guess there's a question I would have is I don't understand the swimming pool, what the concerns were with the swimming pool. You know, I mean, swimming pools are built everywhere. And they're,
We don't know where on the property it's going to be and how that is going to affect access. We don't know anything about it other than its size and the fact that it is now an additional
it's not
permit.
nice at all, not just stuff.
So if I can go ahead. Let's stand. All right. Now regarding health, safety, and general welfare. In December 2021, this board, the Southport Board of Adjustment, heard a similar application for this property that revealed very concerning details about structural integrity and viability, including numerous warnings and cautions from an engineering firm. I trust the planning and permitting staff to have ensured the appropriate repairs and inspections have taken place. But as I said, trust but verify. So I hope you will ask the planning staff to show documentation from qualified experts that the necessary structural repairs and changes have been completed properly. I have attached copies of that engineering
That's
report.
not an issue. But the city staff and that's not an issue.
All right,
We're only moving with the request that we have from the.
it does apply to my reasons for objecting. I need proof that this is not still a danger as the,
Well, did you provide proof that it is a danger?
yes, please see attachment B. That is the
Excuse me.
engineering report.
Wendell?
So essentially, that would be part of our plan review, is to make sure that the structure is structurally integrity. So if there are issues as outlined and this thing, those would have to be addressed before we could ever give them a CO. So just because they might not be addressed now, doesn't mean that they won't be.
Mr. Bondera, would you want to come up with it?
I mean, there's it's hard to address all of this, but I can try to address what I did here. And again, the house or the building is in a AE 11 flood zone. We supplied the flood elevation certificate to staff. It's the base flood is AE 11. The finished floor is AE, or it's elevation 19.2. It's fully compliant with that in terms of where that finished floor would be. As far as the pool is a different question, Mark, and I can't really speak to that.
I don't think that's relevant.
I'd like to, I don't know how to really address all of this, if this is going to be point by point, or I have to try to address some of the concerns the state stands. But there's some questions I'm thinking for summary about whether the lower level is a private garage, and the statute or the language of that, and I think city staff agrees with that. That the detached garage is defined as a use. It's not defined as a structure, meaning that a garage is for motorized vehicles. It's not storage. And a garage has a separate use. Storage has a separate use as defined by the UDO, and I have a handout I can give you that comes right out of the UDO. This center has no intention of using that as a garage. The other, I think I'm trying to sort through some of these questions. I don't know if it's premature to do that,
I'm
but
wondering if I could perhaps finish my presentation and then perhaps you could.
He's got the
Go
floor,
please.
excuse me, he's got the floor right now.
so again, the pools are not relevant. The flood zone, it complies. The center has a permit for some of the repair work that came out of that initial structural work. So that's on record. The center may come up to speak, but there's some language here that I want to address the garage question and why it's not a garage. The other question is, does it occupy 50% of the rear yard? The rear yard is defined by the ordinance is the dimension from the rear property line to the setback requirement. The structure does not encroach at all into that dimension. So what I mean by that, there is no encroachment by this existing building into the required rear yard of the building. So I'm just kind of preempting that point, and so I guess, I'll wait, but I might come back up.
Yeah, we'll let Ms. Davis continue.
Thank you. I believe we're still on page 2, second bullet point. Regarding whether this accessory building meets the standards for a dwelling space. So is this structure appropriate for consideration as an accessory dwelling? Okay. UDO Article 3, Section A.2 states the total area of accessory structures, excluding swimming pools, shall not exceed 50% of the rear yard area of the lot and shall meet all rear and side yard setbacks of the district. So it looks to me like the rear yard area of the property is approximately 2,977 square feet based on the survey drawings in the packet, which you have. 50% of 2,977 is 1,448 square feet. The total square feet of the structure, according to the information presented, is 778 square feet on each of the 2 floors, for a total of 1,556 square feet. And that is an excess of 108 square feet, which is roughly 7.5% larger than is allowed. Can this apparent discrepancy be explained? And would it be reasonable to allow such a large discrepancy? The existing accessory structure has 2 big garage doors opening up into the ground floor. They are not shown in the photos included in the application packet, but they're clearly shown on the building diagrams in the packet. And the definition in the UDO Article 8 states, the definition of garage: a building or space used as an accessory to or a part of the main building, permitted in any residential district that provides storage space for motor vehicles and in which no business, occupation, or service for profits is in any way conducted. It is a garage and a golf cart is kept in there. And that's a motor vehicle. It's a permitted vehicle. UDO Article 3, Section
Excuse me, 1 minute.
3.8. I'm sorry.
Can I ask, would it be appropriate to let you respond one at a time? What would be best? As she rolls at this,
We
you
say,
have to address each one, or you want to wait till the end?
I'm close to the end.
yeah, I'll wait until the end. That way she has her time. And then,
Okay.
Detached, Article 3, C.8. Detached garages with a second floor accessory residential dwelling, which is what this applicant is seeking to have, may not exceed ground level building footprint of 530 square feet. That's very clear in the UDO. The footprint of this structure, according to the information presented, is 778 square feet, which would be 248 square feet larger than the limit in the UDO. How is that discrepancy reconciled by the applicant or the city staff? It looks to me like the downstairs area is either a garage, although it's being labeled storage area, or it's part of the residential area. In other words, if it's not a garage, then how can it have an upstairs dwelling like this? If it is a garage, then how is this proposal for a 778 square foot accessory dwelling acceptable, since the UDO limits it to 530 square feet? Doesn't look like it can be neither or both of these things at the same time, does it? In the event that the structure is deemed not to be a garage, then I come to questions based on UDO Article 3, Section C, which states, point 1, an accessory dwelling may be within an attached or separate from this principal residential structure. Point 7, the accessory dwelling shall not exceed 800 square feet, which I believe is where some of this confusion seems to arise. The UDO does not envision a scenario in which an accessory dwelling unit is part of another building unless it is a main residential structure or a garage. In this case, the proposed accessory dwelling would be part of a garage that appears to be far larger than the 530 square feet that the UDO allows, or the building in total. A standalone separate structure, which in this case is a total of 1,556 square feet. That's the upstairs and the downstairs. Almost twice the size allowed by the UDO. So can the applicant or staff explain how that works? You know, I imagine you will attempt it. That's not the end of my remarks, but a question I know you will get to.
Ms. Davis, I think that it'll be appropriate for Mr. Van Dare to come up and address city staff, because I think a lot of what you're saying arguably requires you to have a certain type of expertise, textual, engineering, or otherwise, so that your conclusions to the effect that there are in fact discrepancies, and there are in fact total amounts of square footage which exceed the UDO.
Attorney Giuseppe, I have to raise an objection to your participating in this hearing because you represented the applicant as their attorney.
He is advising.
Right. As on this application, prior, as to how they should consider if at all information that's coming in. Here, this particular hearing, this matter, new information on the new application at a different time. So all I'm doing is just putting a characterization on what I see your states to be like.
I still object, especially since you have the city attorney present.
You object to this now.
I'm
So you want to
objecting
continue
to
to,
an attorney participating in
you're
this
sorry?
hearing. I am objecting to Attorney Ray Giuseppe participating in this hearing.
Your objection is noted. Thank you.
Thank you.
Would you continue, Ray?
That's all I wanted to put on the record.
You got it.
Again, this board can choose to not accept my advice on that.
Right.
Think about us, state what I'm thinking about it, and then we'll see what the other information comes in, and it's up to the board to decide. Thank you.
If you were you asking, or were you stating that I should be presenting expert witnesses? I'm not an expert. I am presenting to you, I'm reciting definitions in the UDO and things that I personally know from living next door.
But you're also reaching conclusions.
I'm sorry.
You're also reaching conclusions about discrepancies, calculations, which I think require an expertise that you haven't demonstrated you have. That's my only point.
I believe that I have demonstrated it by pointing out what the square footage as presented in the application and what the UDO states the allowable square footages are.
I understand.
I don't have, I mean, what expert would I call to state what I've already stated, which is prima facie in the UDO and in the application?
I still think that what you're trying to conclude is not innocent for those purposes. That's my point.
That's his advice to us.
All right.
I'm here.
Go ahead, Mr. Bender.
I guess I'm just going to reiterate I'm not going to address much more some of the questions because it's difficult to grasp all of it. But again, the definition of a garage is a separate definition. I can circulate this on what that means and what storage means. It's out right out of the UDO as far as the intent of that lower level space. It's considered storage. Ms. Stenner is here to, if you need her to confirm that it's going to be used as it's proposed. And that section is based on use. It's not based on the footprint. It's all used and it's not a garage. The other point is just that the rear yard, again, is measured from the rear setback line to the rear property line to the setback line. None of this building encroaches into that space. So there is no encroachment at all. This structure, there is no reduction of the rear yard. That section does not come into play in this application. That's, I guess, I don't have much to add.
Thank you. Wendell, do you have anything to add? In regard to this?
I have other issues, as you know.
We're
We're
gonna-
still on
we're
the
gonna get back to
garage.
you, man. We're gonna get back to you,
Okay.
please. If you've laid a lot of stuff out on us that we were not privy to prior to the meeting. So we have to rely on different people to help us interpret what you have presented. And so if you would allow us to do that,
Of
I
course.
appreciate it. Thank you.
One of the reasons I gave it to you, so you could have it in front of you.
Would have been nice to have it a week ago, but that's something we don't. But, you know,
I'll just reiterate that, we define garage and storage differently, as Mr. Bender said. And this, and this structure is not a garage, as Ms. Davidson mentioned, the driveway is 7 feet. To get a car there would be really reckless, so it couldn't be operated as a garage. Now, maybe they've stored a golf cart there before. I wouldn't call that a garage per se. I don't know. That's something I haven't dissected or split that hair. And if it is an issue, I'm sure that the applicant would be more than willing to no longer store their golf cart there. But that goes back to the point of saying that, no, we're looking at the structure, not in cubic feet, but in square feet. And the structure, the ADU itself is, yes, it's greater than 530 square feet. However, that provision is only meant for detached garages or attached garages. And I can address any other points.
we'll let Ms. Davis.
If a motor vehicle that is permitted, has a license plate and everything, it is in there and it is kept in there. How does that not make this a garage?
Is that a recreational vehicle?
The UDO is very clear.
It's not.
Motor vehicle, not, it doesn't go into different categories of vehicle.
So if it was a tractor trailer, like a John Deere tractor, would that make it a garage?
The UDO says motor vehicles.
Is there a definition of motor vehicle in the UDO?
I believe Director Meehan's double checking.
Mr. Van Der would like to comment.
I think, just to, and maybe Ms. Stenner might be willing to come up But it's clear that the applicant is not intending to use it for a motor vehicle. That's the proposal. And she's sent an email to city staff stating that. And if she needs to come up and testify to that point, I think she'd be able to. The last thing I'd like to say is that Kylie Barefoot has been doing inspections on this property to do with the structural report. That's been ongoing, that the report from several years back. So.
Thank you.
Hoping I'm done with the logics here. Top of page 4. The top of page 4, that first bullet item. The UDO Article 5, Section H states, when accessory structures, and it in parentheses says, sheds, detached garages, etc., are to be placed within a special flood hazard area, the following criteria shall be met. Accessory structures shall not be used for human habitation, including working, sleeping, living, cooking, or restroom areas. UDO Article 5, Section H states, special flood hazard areas means the land in the floodplain is subject to a 1% or greater chance of being flooded in any given year. This structure is in the flood zone AE, that's EL10, a special flood hazard area according to the USGS 2025 firm map. Attachment C provides that for you. It looks like this in your packet. Did anybody else need to see the reference? I sure do wish I had slides for you. I know y'all know how to read something like this. Everything below the brown zone is AE, and it is AE elevation 10 or above. The red circle or teardrop, that is this property. And you can see there's the front area and then toward the back, and the special flood zone area is in the, or the structure in the back that is the subject of this application is in the AE flood zone, which is a special flood zone area. And so the UDO speaks very clearly on that. I don't need to repeat that for you.
Can I have Mr. Staff respond to that, please?
Yeah, so all due respect, this section 5H1 is taken out of context. Accessory structures can't be used as a dwelling space or none, particularly in a flood hazard area. However, by being granted a special use permit to allow for an accessory dwelling unit to be there, now the onus is on the property owner to bring that structure up to contemporary floodplain standards, which it is. I've done the staff review of the elevation certificate. It is at, as Mr. Bagdera said, it's in the 11-foot base flood elevation. And I want to say the second story where the dwelling would be at is 19 feet. So it's, and then on top of that, it's part of our plan review would be to evaluate the structure for floodplain standards, make sure that there's no static discharge being able to get out and all that stuff. So
Based on the plan that's been submitted and the information.
well, that'd be part of the plan review. Not based off of this right here, because that's not part of the equation for an accessory dwelling unit per se. But we've already done our due diligence there and evaluated the situation. It is up to contemporary floodplain standards.
So it is, yeah, okay, so it does meet the standard and you will address the other issues as it goes through the
Correct.
plan review.
Yes, sir. But that's just to reiterate, no one's allowed to live in a shed, period.
Right.
But particularly making a shed habitable in a special flood hazard area is unwise.
I did include as attachment D, the elevation certificate. I think common sense, dictates that although the second floor of the structure may be high enough to be out of the flood zone, a bad flood that affects the first level is gonna destroy the upper
I'm
level.
sorry, Ms. Davis, that's irrelevant
Okay,
right here, according to what it, HUDO, it's your personal opinion,
yes. Okay,
not relevant.
regarding whether the special use would adversely affect adjoining property, including mine. I'd like to specify that by my best estimate, the existing building is within 100 feet of the interior living space of 11 separate private homes, including the main house on the property. 512 Brunswick Street. It's 45 feet away. 516 Brunswick Street is 99 feet away. But 509 West Street, right behind it, is 43 feet. Remember, I'm talking about the interior space of these buildings. 507 West Street, 67 feet. 505 West Street, 27
Can I excuse me, Ms. Davis, what is the relevance of this to what we're discussing? To engage, I'm having trouble with that.
Okay, this is a very tight neighborhood, even by Southport standards. And if you conclude that any adverse effect could come from this proposed use, please consider the question of whether it could negatively affect the owners, residents, and others in such close proximity who desire safety, security, and quiet enjoyment of their properties. And finally, regarding whether the proposed use will be in harmony with the area. I have no explicit questions about this other than asking you to consider these observations. To my knowledge, there's no other R10 zone property on the block bordered by Brunswick, West, and Short Street that has an accessory dwelling unit.
Again, relevance. I'm having trouble. It's,
We're talking about in harmony with the area. And the harmony of the area is this is not different from anything else.
That's a personal opinion. That's not.
I gotta go up.
uh,
Okay.
Are you ready?
The main structure at 508 West Brunswick Street has a heated square footage of 3,596 square feet, according to its 2018 multiple listing service report, which shows the main house is having 5 bedrooms and 4 bathrooms. This is already a very large residence.
Yes, yeah. We,
Okay.
again, so that's.
Well,
I appreciate where you're heading with it, and I've heard you. And I understand how dear it is to you, and you made that reference.
okay. Well, I mean, if I may conclude, I hope I made it clear that I'm not here to try to tell you what you should decide. I'm letting you know what I hope you will decide, but I hope you will get answers to the questions I've asked before you make a decision. And that's all.
What question, I'm not aware of any question that hadn't been answered by staff or here. And unless you have some expert testimony or other information that we haven't seen. Or, I mean, I feel comfortable, just other members of the board feel comfortable with what we've heard. Any issues with what she brought up or with questions of Wendell? Okay. Wendell, you have anything to add?
No, but I'd be more than happy to stick around and answer any further questions.
We do appreciate that.
Yeah. The bug in the alignment here is the square footage of the structure. And I see it's ultimately, do you guys define this as a garage or do you define it as a storage unit? Staff, I've spoken with Director Meehan about this when the obstacle came my way. And we both came to the conclusion that it's a storage unit. And then we got confirmation from the property owner as such.
Well,
That's why we don't concern ourselves with item 8, limiting it to that 530 square foot.
and depending where we go with how the vote goes.
Yeah, I'm just saying
It
that's
could be,
the
it could
only
be a condition.
ointment that I can think of, or bug in the ointment that I can think of as the next issue.
I got you.
I do believe the property owner did want to say
Yeah.
something.
Ma'am, please.
To speak.
If you feel the need to, but
I'll be brief.
yes, ma'am, come up, step up. please.
I'm sorry.
Your name?
Jennifer Center, 508 West Brunswick. And
Sure, the truth, whole truth, and nothing but the truth, so you got it. Thank you, ma'am.
we can't help that our lots are small. All the structural things were completed and verified and permitted. Continue to go on that if there's anything new that arises. I talked to the builder and he said for the inconvenience, the structure is already there. The exterior's already done. There's not painters going on the outside. All it is interior work, which he said he could do in about 3 months.
Will this be used as a garage?
No.
Thank
you.
Question,
Yes.
tell me about your golf cart that's in there. Is it
There's
licensed?
a golf cart in there.
Is it
And-
licensed
It is licensed.
state?
Yes.
Then it is a bid.
So I think it could be outside if that's a requirement. I thought it was safer when I leave because it's not my primary home. Else, anybody?
May I add something? If the board chooses to grant this application, would there be a condition that the dwelling could not be rented separately from the main?
I can say it already was in the last 4 years, Bill. I agree. It's not.
Existing ordinance prohibits.
Right. And we have a standard add-on to our accessory dwellings that we always had that cannot be rented, so.
And I agree that the electrician and the plumbing.
Not crosstalk.
That can be
House
changed.
last time, it's the same, those fees.
Questions? Any more comments? Questions, staff, of staff, anybody or? Yes,
Are there any more speakers?
yeah, are there any more speakers? Yes. Please come up, sir. Sure. I thought they were all here from that. Me too. Name and address, please.
Okay, I'm Woodrow Wilson Jr., live at 502 West Brunswick Street, right next to the Reverend Love Davis.
Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth. so
I
help you God.
do.
Thank you, sir.
I will be as brief as I can be. I will not recover, go over any of the things that Reverend Love Davis has gone over. I moved to 502 West Brunswick Street in 2003. August of 2003. This same structure, this same building was a topic of discussion then. There had been city stop work orders left and right on it. When Wayne Strickland was the building inspector, we went through all of that situation with him. It's been a debacle from day one. What I would encourage, and I thank you for the leeway to say this, make a decision. We don't care whether she puts what she wants to put in there or not. Just make the decision and let's be done with this thing. 25 years of fooling with this building is a little much. So having said that, thank you all for the opportunity.
Thank you for your comments, yeah. Anybody else?
Debbie Barnes, 425 West West Street.
You raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. So, yeah. Thank you, man. Well,
I had signed up to speak, but you actually addressed it, but I just thought I'd bring it up again since I did sign up to say it, which is, I think if they are wanting to turn that into an accessory building and it adheres to the UDO and the R10 zoning would break. The rental is one we wanted to make sure got addressed and now you've addressed it. And so, thank you.
thank you, man. Any more questions? Yeah, okay. So I can close this public hearing. And then discussion, any discussion or questions, what's that? I mean, my board members.
May I stay here? I have trouble hearing back there.
Oh, yeah, you're fine.
Okay.
Yeah.
I think it's a myth. But today it is used as a garage with the licensed golf cart in it, because that has been a big mistake. Lightweight bid, which would bring it back to a garage now. I do feel that it could be appropriate that the board say, okay, we need a qualification stating that vehicle will not be housed in the town garage.
I don't know how the vote's gonna go, but however it goes, we could put that,
Understand?
we usually handle this at the end.
Proposing a condition that, golf.
We're not there yet. No, Rodney. Well, no, I mean, question. Oh, yeah, go ahead.
That means that someone having a motorcycle and brings it in the front door in your house garage at that point.
Kendall?
It's just a smelly house.
License vehicle.
So your house becomes a garage?
Yeah, yes. Tonight.
Rodney, what was your question about Harley earlier? I didn't mean to shut you down.
No,
I would say garage. I'm sorry,
I would say-
I was asked, are you doing mechanical maintenance on a vehicle?
If you don't want to be
That's-
rained on.
When you think of it, like, at least when you think of a commercial garage, you think of car lifts and oil or you're thinking of cars on display, things like that. So that, for my part, to that point, no, your house would not be a garage.
I think we have the right to tell someone what they can and can't put inside.
Well, it's still relevant. I mean, why, what, if it's a garage or storage, it's already built. I mean, a square footage is square footage. You're not gonna shrink it.
It's not only renting ADU though.
Yeah, but the building,
Let me, if I can interrupt, Article 8, page 15, the garage private, I think this is what Rich, a building or space defined as a building or space used as an accessory or to or a part of the main building permitted in any residential district that provides storage space for motor vehicles and in which no business occupation or service for profit is in any way conducted. So. And storage definition. A deposition of commodities or items for the purpose of future use or safekeeping. Those are our definitions. Depending on again how the vote goes, I think all these issues could be addressed. We'll see. Okay. Close the public hearing. Any more questions or comments? So where are my motions? Yeah. Do I have any motions in regard to this application? Motion one, the use for, well, I'm gonna get that. I have a motion.
I move that, the use will not materially endanger the public health, safety, or general welfare if located where proposed and developed according to the plan is submitted and approved. Finding of fact being that the living area of the ADU would be well above flood elevation level.
Got a second?
Second.
All in favor signify by saying aye.
Aye.
All opposed, same sign. For the public here, I don't vote unless it's a tie. So you know why I'm not voting. That motion carried. Motion two.
Motion to use meets all required conditions and specifications.
We'll have a second.
Need finding. We need a finding of fact. It literally complies with.
It complies with UDO.
And says it's fully compliant with what applies. Just got to say. Thank you.
We'll have a second for the second.
Yeah.
All in favor, I say,
Can you have a discussion? After the second, move it to the point, right?
Yeah.
I'm gonna bring that one back up, and I think we can handle it through qualification, but I think it's a fact that the vehicle that's there is a motorized vehicle, which our UDO says would then make it a garage. To your discussion, we're not here to say the UDOs needs to be changed or reworded, but it is as it is for us to deal with now. And that was consideration when you vote this one.
Definition that you read. Is that from the UDO?
Yes.
So
Okay, we had a motion and a second. Some discussion.
And final.
All in favor of this motion signify by saying aye.
Aye.
Opposed, same sign.
Okay,
Yeah, motion carried. Motion approved.
Okay. The use will not adversely affect the use where any physical attribute is joining or abutting property that for that use is a public necessity, finding fact the buildings there. It's changing from the exterior role to the interior project.
Oh,
I'd also say can this also be a finding of fact that the, location, of this use within the historic district of Southport is very similar to other uses, i.e. all houses virtually are close to their neighbors' driveways and accessory.
I wish I had a driveway.
Goes.
All in, yeah, that we can add that. All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. That motion carried. Motion 4.
Chair,
Yes,
who seconded that?
Rodney.
Thank you, Mr. Ross.
Motion 4.
A motion, the location and character of the use, if developed according to the plan, is submitted and approved, will be in harmony with the area in which it's located and in general conformity with the city of Southport comprehensive plan. Findings of fact are that it meets all the requirements of the UDO and the comprehensive plan. And all, period. And then all, again, basically the same thing I said before for 3, that the, as submitted and approved does not create a situation of more conflict than already exists throughout the historic district.
Okay, discussion of that?
Second to that.
All in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carried. Motion 5.
I recommend it's not a motion, recommend the approval of the special use application with conditions, including the following, the no rentals, whatever we recover. Stock user for that.
Yeah, no rentals separate from the primary residence.
And then at the garage, I mean, you can say,
The structure will not be utilized for the storage of a vehicle. And then I'd like to.
Well, let me ask you a question.
Approval of the, that qualification.
It's licensed vehicles. Is that what we're talking about? Licensed vehicles?
No, we're talking about motor vehicles as defined in,
Okay.
Jar.
which is any, hang on, it's any conveyance that moves over land or water. On its
So,
own power.
back to our lawnmower. That would not be allowed to be in that building.
It doesn't make sense to me. Okay.
Okay.
By definition, it would be.
Okay, all in favor?
Yeah.
Motion 5. Signify by saying aye.
Well, we need to have the qualification in there for the question of the position.
I don't, the 5th one,
We've always done it after the, well,
That was part of
the 5th one doesn't have any findings of fact.
Has conditions for saying that.
Right.
Motions to approve.
and we typically added those after the
Rental and all that.
So, yeah, but Harley, you're right. Is there, have we covered the vehicles? And the issues that,
So just to recap, there's 2 conditions we're putting on it. No rental of the ADU separate from the main house. No storage of motor vehicles in the accessory structure.
yeah. Okay, is that good? Oh. Okay, all in favor of that, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Yeah, who second?
Rodney here.
Rodney, yeah. The motion carries. So we have made approval of this project and the gentleman who spoke last, hopefully this is done. We made our decision, we can move forward. So thank you. We're gonna take a break, 5-minute break before the next hearing, please.
Thank you.
Please.
Thank you, Jacob.
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 Please.
Thank you, Jacob. Thank you. 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 Thank you.
All right, folks, coming back into our meeting here. We're here for the last one is an appeal of an administrative decision by our code enforcement officer. Setting rules apply, as we did earlier. We'd like to ask that the attorneys will come first with their opening statements, and then we'll proceed with the staff reports. Let them make their statements. You want to go first?
I'm going to be very brief. So that's okay. Go ahead. Yes, thank you, Mr. Chairman. Good evening, members of the board. Brady Herman here on behalf of city staff's position in terms of this notice of violation issued before you all regarding a fence encroachment within East Bay Street on the property owners at 410 East Bay Street, Augustine Claire Adams.
I think facts, the essential facts in this case are not in dispute. There is a fence that is located in front of the appellant's house within East Bay Street. And it's clear that the city's ordinance, both at the time of when the fence was allegedly constructed and today, is in violation of the city's code of ordinances and the design development ordinance, but in particular, the general code, section 16-8 and 16-10. I'd like to go ahead and at this time pass out to you all just a brief legal memorandum that you all can read through during the hearing, just to counter some of the arguments and defenses that opposing counsel might go and have in regard to this issue. I've already given opposing counsel a copy of the legal memorandum. It is outdated in terms of the date, as I had it from last month. But I just want to state for the record, this is my first time giving this to you all in this case.
It's the same thing.
Yeah. Just real quickly, again, I want to go over the standard review for you all. So the decision for you all is to decide whether city staff or its decision is issued the notice violation to the appellants. Okay. The notice violation for the appellants, and so you all review that decision anew based on substantial competent evidence that's submitted to you all at this hearing. And we proffer that the evidence and testimony will show that appellants are in violation of this ordinance, and that the appropriate remedies are upheld on the basis of city staff decision, in particular, Mr. Derek made with Code Enforcement Alliance. I'll first call Ms. Meehan to provide her staff report and testimony, and then I'll also call Mr. Derek. Thank you.
Good evening. I'm Greg Cleva. I'm an attorney in Oak Island, and I'm here representing the appellants Claire and August Adams regarding the violation order that was issued on September 11th of 2025 regarding the fence at Bay Street. The facts are, as Mr. Herman said, they're pretty straightforward. There's a fence that is alleged to be in a right-of-way on Bay Street, which is incidentally a 100-foot right-of-way as opposed to the standard 60-foot right-of-way for a street. And if you believe the evidence will show you that if you look at where that right-of-way ends, it ends at their front door. So if they open up the door, they're in the right. So we're not here to make any kind of claim of adverse possession that we own the right-of-way or that they own the right-of-way or they own any part of it. But what we do believe the evidence is going to show is that sheer common sense is going to tell you that this fence has been in existence for over 40 years in the same location. It's been there. There's other owners of the property who are here to testify as to where it is. We believe the evidence is going to show you that this fence was in plain view, not obstructed by anything. You can see it from every aspect of Bay Street wherever you are. It doesn't impede foot traffic. It's in fact on the opposite side of the street than the sidewalk of Bay Street. It does not impede the flow of traffic in any way. It does not impede anything that the city intends to do with the property. So what simply may fall as just a fence inside of a right-of-way is not just determinant of whether or not that fence should be there. Okay? They didn't construct the fence. Okay, and we're not claiming adverse possession, but this is not a fence that was put up in a year. Not a fence that was put up within 5 years of the UDO. It was a fence that was put up 40 years ago, or some form of it 40 years ago. And there's nothing that the city or the citizenry of Southport gains by making them take the fence down. The only reason, and the only thing the city gains by making them take the fence down is that it's in the right of way where it's been for 40 years. It doesn't advance any purpose whatsoever other than that. So the presentation that I'm going to have tonight is not going to be extremely detailed. in terms of, we're not calling, there's not a lot of pictures, there's not going to be that. What it's going to be is common sense, asking the Board of Adjustment to do just that. Adjust what is there based on the facts. I believe that the facts are going to show, just like what I said, that this fence has been in existence for over 40 years. It's caused no problems to the city. There's been no complaints about the fence in the city. The only reason why it's here is because there's a fence alleged in the right. So I'll just reserve time to end closing it for the evidence presented. I believe I would have two possible witnesses. It would be Mr. Adams and Mr. Sidney Ford. Thank you.
Thank you, sir. Mo?
Yes, sir.
Mr. Ethan? And you are who?
I'm Maureen Lehan.
Okay. You swear to tell the truth, the whole truth, and nothing but the truth, so, yeah.
I do. Good evening, Chair, members of the Board of Adjustments. This evening, I'm going to go through some of the basic information about the case itself. Some of it, I don't want to go too far in. This, like we've said, is very basic. The attorneys have covered some of this information already. So this is an appeal to an administrative decision. Mr. Cleva is for the property owners of 410 East Bay Street. They are appealing the final order that is dated September 11th. That was issued by Code Enforcement Officer Derek Mabe for violating both the City Code of Ordinances and the Unified Development Ordinance for encroachment in the right-of-way in the form of offense. So it's City Ordinance Section 16-8, obstruction of public right-of-ways, and the UDO Section 3.17D, landscaping of public property. Both of those mirror each other, basically saying it shall be unlawful for any person to place or cause to be placed on any public street, road, alley, sidewalk, or other public right-of-way within the city, any wall, fence, gate, brick, stone, wood, rock, vegetation, or other structure, material, or substance above the horizontal plane of the existing ground. So just to give you just a basic understanding of what the ordinance, those sections of the ordinance say. This is a survey that was prepared for the property owners in 2024. It's in your packet. I was able to clarify it a little bit better, give you a little more clarity on it. And some photographs that were taken that I was able to take off the Google Street View. It shows the fence in place. If you will notice the front lot line, like they were saying that the porch almost is on the front lot line there, you'll see. And then the subject fence is out into the right of way just before the first edge of pavement on East Bay Street. And the right of way goes 49 and a half feet to the other side of the pavement on East Bay Street, their property. Some more photo documentation. This documentation was taken in May of 2024 by Derek Mabe, the Code Enforcement Officer. This documentation, again, was made in May of 2024. The violation was sent in 2025, January 2025. There was a delay in the issuance of this notice of violation. At the time, the Board of Aldermen were discussing right-of-way encroachments, right-of-way enforcements, and potential amendments to the ordinances. So we were holding off on this case while the case was open. The notice was not sent. On December 12th of 2024, the Board of Aldermen did approve amendments to Section 16-8 and 1610 of the City Code of Ordinances with the directive that all hardened structures must be removed on any existing right-of-way. So this is going to be the obstruction of public right-of-way and existing encroachments in right-of-way where the amendments were and the directive to have all of the hardened structures. Yes.
Would you please define hardened structures?
I don't have a hardened structure per se, but I would say that it would be taken that as the definitions or how it is defined as an encroachment, the obstructions themselves in the Code of Ordinances, that includes the walls, fences, gates, bricks, stone, wood, rock,
or any structures above the horizontal plane be considered a hardened structure.
Above the bar.
Above the horizontal.
The other directive was that any open cases that were existing with right-of-way violations must be enforced. I wanted to just kind of go through the timeline of this case itself. So as I mentioned, the first notice of violation was delivered in January of 2025. Then there was a reinspection that occurred in March of 2025 with no progress. A hearing was set for May of 2025. There was a conflict with the owners, so they were not able to attend that hearing. Then a new hearing was then scheduled in August of 2025 to accommodate the property owners. The hearing was held. There was no, again, there was no removal of the fence. So the final finding of facts and final order was prepared and sent to the property owners on September 11th, 2025, as mentioned previously. So as just a conclusion, the fence is a hardened structure located in the city's right-of-way in violation of the city code of ordinances and the city UDO, Unified Development Code. Therefore, we request that you reaffirm the initial and final notice and finding of fact sent on September 11th, 2025, ordering the applicants to remove the fence from the city's right-of-way. And that is the conclusion of my presentation.
Is this based on the 1224 modification to the UDO or whatever?
So the UDO and the city ordinances had these clauses that you could not have encroachments in the right of way previous to the December amendments. So this case was open prior to those amendments. It was not noticed until further because of the amendments that were being considered and how the alderman wanted to move forward with enforcement of existing encroachments.
And the storage area has not been determined yet, the overlay, the storage district.
That's correct. There is not an official local historic district. If there is a local district as it is being proposed at this time, if it is adopted, yes, this piece of property will be within the historic district, the local district.
I'm sorry, I didn't hear the end.
Yes, in the local historic district. I want to clarify that.
It will be, not now, but. it will.
Right, yes, if
it's adopted.
If it is adopted, yes.
When it's adopted.
No, I vaguely, it's a vague memory. That's it gets me in trouble a lot. Wasn't it? I thought there was an exception carved out for structures that were this old, 40 years old. Wasn't there an exception?
There are exceptions that were written that include older fences
Right.
prior to 1980, but it also had to be part of, in the historic area it is, had to have a curb and a sidewalk. And then this would be located on the property side of the sidewalk.
But it doesn't have a sidewalk.
Yes.
Yeah. okay.
Yes, correct.
Yeah, okay,
Yes.
okay. Yeah.
As it exists on your side.
Okay, I got you.
Can you describe that stretch where the street flows into the yard there? Is there a curb or any kind of?
There is a curb in that area.
There is.
Yes.
An asphalt, little
Yeah, it's
asphalt.
just an asphalt
Yes,
lip.
it's not a true curb and gutter, but it is, there is a.
That asphalt,
Curb or on the,
yeah.
No, there's not a. Yes, sir.
on this slide, the left side where this survey drawing is.
Yes,
It looks like, excuse me, there's the fence is delineated there. And then
Yes.
there's what is that curving line? Is that
that's
Is that-
existing walkway.
is that walkways?
Yes,
But that's on the right of way.
that is in the right of way.
Is there any request or effort from the city that those be removed?
No,
And that's because they're
they are left.
horizontal.
That's correct.
So,
Are they grandfathered in on the sidewalk?
Yes, and you, at this time, you still would be able to we allow property owners to have access to their properties with walkways and driveways through the right of way. So that would not be in violation.
Is that considered a sidewalk then? Is that walkway?
Well, a walkway to your home,
I mean,
access
does
to
that,
your
does that
home.
fall along the lines of what you just?
No, I'm sorry, no, that would not be considered a sidewalk in the definition that I was speaking of. It's-
Is 100-foot right of way unusual in the city?
No, it is very common throughout the city.
How long is this area, where this property has been platted?
This is one of the, a portion of one of the 100 first lots,
That,
1792.
that right of way's been there.
That has been designated right away since that time, yes.
99 feet or is it 100?
It says 99.
Yeah.
Gonna make math work.
That's our favorite.
So in terms of proposed violation, there's only the L section that is considered in violation. That
The fence.
there's two pieces, yeah.
There are, so there's two pieces of fence.
Right.
The fencing that borders the driveway and the portion that is within the front yard.
Right, it's
Yes.
only the front yard portion.
This is for all the fencing in the right of way.
Okay, because I'm looking at the exhibit, and the exhibit says subject fence.
Okay.
And it's, I need to, okay, it points at, if there's two sections of fence that are in violation, to me, I just want to level the floor here. It needs to show both sections of fence. Right now, it only shows one section of fence. And I just want to be clear, we're talking about every piece of fence
That is within.
within a right. Okay, thank you.
You're welcome.
So following up on that, we're talking about stuff that runs parallel to East Bay Street and the first section or two of the stuff that.
Could you point that out with the pointer mode? It's all in. Yeah,
Yeah.
I don't know. I don't think the back.
Two sections,
I can't.
two sections are straight and a complete L.
So that, yes.
Picture. Do it on the picture.
Right, so I'm trying here, okay, I'm sorry. So this would be the section and this is just, I would say these two first sections would be considered within the right of way.
Just as show.
That's correct. Yes, sir.
So those would be removed.
Yes.
Is there an instrument or avenue people can request for the city, any kind of permit for structures like this in the right of way?
Not for a fence, no.
I don't think you can plant tulips.
Not. Unless it's under a tree within a 10-foot diameter of an existing tree.
If previously, prior to this revision, how were the right of ways managed? In that if homeowner had something out there on the right of way, how was that managed?
They were managed.
It wasn't.
There were most that they weren't.
I think, yeah.
Well, what I can say is I don't know.
Okay.
Previous to my employment, I don't know how they were. I have hearsay of how they were managed. I know that when I started my position with the city, it was very clear that I was to make sure that no new encroachments were made in the right of way.
When was that?
That was in October of 2022.
And about existing.
Did you ever hear?
There was no directive on existence.
Did you ever hear for consideration? If you have it there, you may leave it there, but if it becomes a situation that we need it, we'll have to take it off.
No one said that to me directly. I heard rumors.
That around?
I heard rumors, but that's again,
That's
you're
the way
saying, I don't know if that's the
Well, I
direction.
can, nothing to do with Southport, but that's the way it's managed in many towns.
Well, I will give you my experience. When I moved into town, I wanted to put a driveway out in the right of way. And I was told to go to Wayne Strickland
and check with Wayne and say, you know, and he gave me the speech that, hey, it's okay. As long as you understand if the city ever needs it, they're gonna, if they tear it up, you're on you. And,
That's exactly what I meant.
right, and that was,
Well,
and then
I've never heard it myself, so
They've got to
I mean, I
put it
can't
back
say
to a
what
certain
did or
degree.
did
Pardon?
not.
They have to put it back to a certain degree.
well, I mean, they would,
Not your improvements.
No,
no,
They have to put
I
it
mean, they
back.
dig up my bricks.
They have
If
to-
they dig up my bricks, they're not putting back the
Not
bricks.
the.
not what I put out there.
Yeah.
But, and I guess my question, Ari, in light of the fact that the alderman subsequently changed the ordinance, it's irrelevant what past practice was.
I'm gonna get to another side of it. And that is, why not grandfather for that approach to the situation?
Well, I think they have. I mean, if you
wait, hold on,
read,
Charles. That's
what
what
is it,
I'm-
80 years? Is that the grandfather thing in?
The fence is not considered a net, as I heard, no. Tell us.
No, that's not grandfathered in.
But they grandfathered all those things that were at grade, you know, like the driveway.
They allowed
and things like-
vegetation to remain.
Right,
So
like
any vegetation
vegetation and that,
remains.
but any hard structure above the grade is where they went.
That's correct.
Questions of Mo?
Yes, this will sound a little odd, but I'm just curious. I have a suspicion there's probably a good number of violations similar to this throughout the city, where we have an existing fence that's in the right of way to some extent. I'm just curious about, for lack of a better word, the priority or attention that's being given to this one relative to perhaps other similar situations throughout the rest of the city.
So in January 2025, once this new ordinance was put into place with the directives, there was a 6-month grace period that was given to anyone that had a hardened structure that was identified by the city that needed to be removed. And then the city staff worked with those property owners to remove them.
Okay.
Once the grace period was up, anyone that had remaining properties, we formally gave them a notice of violation and went forward with the violations as any normal violation of the code. So currently today we have one left with hardened structure. We were working to get the final.
Correct me if I'm-
That is not included.
So there's two.
So there's 2.
And how many did you start with?
There were 88 that we had identified. About an eighth of those were then given some different priorities that weren't required to be removed due to engineering reasons, or we were given some other local policy that we were able to use. So I would say 50-ish, I would say. Had to have things.
Were any fences or
Yes,
walls
absolutely.
allowed to stay?
Yes, there were some that were allowed to stay, yes.
And what criteria was used?
The criteria was if there was a curb with a sidewalk with a fence that's in the right of way, that was really the fence one. Or any of the walls that you see around the city, that are the older stone walls that you see. And then we were also allowed to have retaining walls remain that were holding up earthen structures that were going to be, if we had them removed, it would be detrimental to the property, the city's property, or the street, or any of the utilities that are existing around it. So those were,
Some engineering related
yes,
structures.
yes.
Can anyone pour a driveway? Right away? Like go out there and pour a driveway?
You would need to get a right of way for that, but yes,
What's this, that the new standard's what, 18 feet,
20.
20? Okay. 20 foot wide.
Yes, we
Driveway,
do allow people to access the property, that we can't stop any.
are you allowed, how many driveways per property?
Sorry, I meant sidewalk. Did I say driveway?
You said driveway.
I apologize. I meant sidewalk. Can it,
Yes, you could get a sidewalk, same, you would
so could
either,
a sidewalk go between that fence and that curb and call it a day?
I mean, it had to be existing at the time that the
Okay.
ordinance was passed. So.
But did I read somewhere where this thing had a rope fence back in the early,
Hey,
no, before that?
No, I thought it was up the street.
No,
I think Dora said something.
When
When did you buy the house?
I think they-
1980, 84?
The original.
That isn't that for her in there.
Yeah, I read that. I talked about 1980, 84.
Something like
The
that.
original, owner who put up was he the one that put up the rope fence? Original builder? The house?
That's what we.
Was that the Spencer family?
Yes, that is what the information that we're.
I mean, I thought that's the information I read that.
But that house was built in 1996. When was it?
97.
Okay.
That doesn't sound right.
No.
It's not.
No. Let's go back to Dora's. Dora's affidavit.
Yes.
Yeah, that was earlier.
She purchased it in 97, Doris.
Probably about 80.
Somebody looked that up.
Probably about 85, I would think.
Spencer bought it December 4th, 1980. I believe it was a vacant lot at the time.
And
Please, I think it's not.
Notification of, your situation. Was it ever stated by the city what that was standing in the way of? Why would I have to do it now? Was that ever looked at?
It was at the time, the city was trying to get all of the right of ways open without hardened structures above the horizontal. That was the
But
initiative.
any I needed for this.
No, sir.
And I think that's what this committee deals with, the variance and other big problems.
Do you have another follow-up, Jason?
So I just want to be clear, at least as late as 1980, this was still a big lot, a bare lot, or didn't have anything on it. The house came in sometime in the early 80s. Is that right?
I would.
I believe that's when Mr. Spencer bought
It
that.
was finished in 81.
80.
We bought it December 4th of 80, so he couldn't build a house.
It says the road fence was installed by the Spencers at the time they constructed the residence upon this.
They had a fence line with that
And it remained in
Posted.
place until
post
97.
and rope. Whether
Doesn't matter.
if it's wood or rope and post.
Any more questions? Sure you'll be back.
I think it's starting my case yet, but yeah.
Good.
Cut it in half.
Last week.
When are you getting up to,
I was gonna give her my seat. That way she didn't have to check out too far.
Mr. Herman, I guess is your,
May I proceed?
please.
For housekeeping, I'll go ahead and enter in city staff report and city's exhibits A through J to the record. And I'll just be referring to the staff report, or excuse me, the agenda pages, so everybody's clear on what page I'm going to. First, Ms. Meehan, are you responsible for adopting city ordinances?
No.
So your job is not to go and create policy, is that right?
That's correct.
And whose responsibility is that?
For this instance, it was the Board of Aldermen.
The board of aldermen makes those decisions for UDO and general, is that right?
Yes.
So your job is to go and enforce the UDO as well as Mr. Maid in terms of the general code of ordinances.
Take me at this survey right here, and that says Exhibit B into the agenda on page, looks like it's on page 60. Page 7. Is that a recorded survey plat,
Recorded. No,
like in the public registry?
no,
So how did the city go and obtain that?
that was part of a building permit.
Okay, okay, so that's something it's in the city record.
That's, yes. it's-
Okay.
in that sense.
Take me through, so in May of 2024, code enforcement officer, Mr. May opened the case, is that right?
Yes.
And at that time, what was the city's ordinance in terms of fence encroachments within the road?
It was, as considered earlier,
So if you go to
yes, I apologize.
exhibit D1, page
D1,
75.
yes, that's the exact.
Okay, and so fences in the right of way are not permissible according to section 16-8, subsection A.
Correct.
Okay, and if you look on exhibit D1, it has parentheses at the bottom. Is that right?
Yes,
And what does that tell us?
that tells us when the ordinances were originally adopted and also when they were amendments were made to those.
So according to this, it says code 1974. Is that right?
Yes,
So that means that this ordinance has been in effect since 1974.
yes,
Well prior to the alleged, or well prior to the time when the first owner purchased the lot and built and constructed a house on there, presumably any fence. That matters, right? Okay.
What was the date on that?
1974.
The UDO was first.
And if you flip over to page 77, this is also codified in the UDO, is that right?
yes,
At least at the time of May of 2024, it was also UDO.
yes.
And if you keep flipping over on exhibit D3, what does this mean here?
That is a copy of the, or a portion of the Unified Development Ordinance that was adopted in 2000.
Okay, and is this as far back as the city records have in terms of previous UDOs?
Not as far back, but that we can find with this.
Okay, I got you. And again, it goes through sort of the existing encroachments on the right of ways. It recodifies essentially what's in the section 16-8.
Yes.
So we have May 2024, Mr. May goes and opens up the case. So it's an open case. Was this the only right of way encroachment open case at that time, May of 2024?
There was one of them.
Okay, so there was two at that time. Now, Mr. May, it took him, several months after that to go and issue the first notice of violation. Is there a reason why a notice of violation just wasn't issued right there, 2 days later to the property owners?
Yes, there were conversations with the Board of Aldermen at the time about encroachments, existing encroachments in the right of way and how they may or may not be enforcing. So we were kind of saying it so that to see how they may fall on the decision on.
Right. So during that time, I mean, how many public hearings and meetings and discussions did the aldermen, who again are the policy creators, how long did that go and take for them to actually go and make a decision?
Months.
Okay. And so at that time, presumably, whether it was staff or the manager told Mr. May to hold on enforcement until a decision was made by the aldermen what they're going to go and do in terms of updating or not updating. Okay. So take me through December of 2024, looking at exhibit I there. So that was the ordinance that was adopted in December 2024 by the, right?
That's correct.
Can you walk us through, because there's a lot of discussion about exceptions.
Okay.
Okay, so let me back up. First, are the appellants in violation of the newly adopted ordinance in December 20?
Yes.
Okay. Specifically, section 16-8, yep, and 16-10, is that right?
Yes.
Okay. So walk me through, I guess, the proposed changes that are relevant to this case. And I think it's important that we go over the exceptions that were, again, decided by the alderman at that time what and what was not.
For clarification, did you want me to say the changes that were made or very specific?
What are relevant, I'm not trying to take too much time. I think it's important that we use this language in here to go over what exceptions, because I was loosely talking about. Okay.
So what page you looking from?
Yeah, oh, excuse me, I'm sorry, page 87. 87 through 89, city's exhibit.
Yes. So exhibit I, if you look at 16-8B, that's where we're speaking about the 2 parking spaces of 20 feet total width. And that would be where the driveway would come in on that. It also outlined what types of paving would be allowed. The UDO administrator could waive requirements for wood border if necessary. Really, for this property itself, that nothing else in this section. Then we would talk about.
Those like exceptions, it might be.
Yeah, yes, it's gonna be for the existing encroachments, really, for 16-10. B, so that vegetative encroachment.
Right, on page 89.
On page 89,
Yep.
correct. That's where it outlines that you are able to keep existing, any vegetation that was existing prior to the adoption of this ordinance in December of 2024. They're permitted to be expanded as long as, and then the city has the right to remove them if necessary. Also, you're allowed to install native trees when a city tree must be removed for construction, or if there is a diseased or dying tree that you want to replace in your home. Then this next one is where the curb and public sidewalk exists. Private fences, walls, and vegetation installed up to the private property side of the sidewalk existing at the time of the adoption of this ordinance may remain. All approvals and building permits must be obtained for maintenance or replacement.
So just stopping right there, that's a grandfathering in provision right
That's
there,
correct.
that's correct?
Yes.
Does subsection C apply to the appellants in this case, according to how that ordinance is written?
It just,
Okay, and continue on to subsection D.
the next one is any fence or wall located in the right of way in the designated National Historic Register or in a local district built on or before December 31st, 1980, may remain after written determination by the UDO administrator or the Historic Preservation Commission that the structure contributes to the historic.
And does that exception apply in this case?
No.
Continue going to page 91, exhibit J. Is this the minutes from the Board of Aldermen meeting where the alderman adopted that ordinance?
Yes.
Exhibit I. And if you turn all the way to page 93, can you summarize what Alderman Mosteller's motion was in terms of approving and what, I guess, add-on she had in terms of open enforcement cases at the time?
Yes, so her motion was to adopt the ordinance as we just reviewed that was adopted, but also saying there was a 6 months grace period for enforcement for those existing to allow us to work with the property owners adjacent to these. And then it does mention that any active code enforcement cases prior to the adoption of this ordinance shall remain in place. So we must move forward with their enforcement.
And that includes the pallets. Is that correct?
Yes.
And there's one other property that
Yes.
was an open enforcement case, and that was also on East Bay Street. Is that right?
Correct.
So according to the direction, again, of the alderman for staff, was there's no grace period for open enforcement cases,
That's
right?
Yes.
Which is why the code enforcement officer, Mr. Mabe, and his staff sent the notice of violation.
That's correct.
I'll go through the timeline. Go back to the discussion which was the question that I was really wanting to go and get to, but just a little bit more clarity. You know, we have January, we got to go and tell all these property owners they're in violation. So roughly how many were in violation of right of way?
88.
88. And I guess as of today, how many of those have come into compliance?
All but one.
And to your knowledge, are there other property owners in the exact same situation as the appellants? Maybe not necessarily the same street, but that had a fence that is in front of their property, not within their property line, but within the right of way, that had to go and remove their fence?
Yes,
And did they go and comply?
yes.
And you said there's just one outstanding as of now.
Yes.
You know, I think it was discussed briefly, but this term grandfathered in is another word for that, sort of a non-conforming use.
That's
And can you explain to the board why this could not be considered a non-conforming use? I could think of several reasons, but just a generalized sort of, in your expertise of why this would not be non-conforming.
And non-conforming structure has to be legally established, able to be legally established at the time of the change of.
And this has always been.
That's correct.
Is that right? And another contention or allegation raised by the appellants is that they didn't go and put up this fence. So whether it's a general code violation or a zoning violation, if I create a illegal use on my property and I sell that property to somebody else and they continue that illegal use or the illegal violation, does that absolve the subsequent property owner in terms of being allowed to continue the violation or not?
No.
So in other words, they would have to, as long as they were cited, just because the first person wasn't cited, the second one, just because they continue the violation, they would still be in violation of the general code or the unit. Is that right?
Yeah.
Okay, I think that's all I have.
I have a few questions, just touching on what you said, that was raised that there were other property owners that were in violation of the UDO when this enforcement came down. I personally don't think that that's relevant to this property, but did any of the other property owners, to your knowledge, appeal any of the orders?
There was one, well, not in the sense of